Hello, and thank you for joining us today. My name is Pascal Bird, and I coordinate the Legal Advisory Service of Legal Response International, LRI. If you're not familiar with our work, LRI provides free legal support to developing countries, low-income developing countries, and the NGO that work with them at the UN climate change negotiations. We also provide support to the same countries in the implementation of the Paris Agreement. And we do this in a number of ways. We respond to ad hoc requests for legal advice, and we also produce publication on national implementation to help inform policy and law decision makers in their review and development of new laws and policies. And today we will be talking about a new paper that we have just published, which is a comparative legal analysis of climate framework laws in Latin American countries and their alignment to the Paris Agreement. And to joining me today to discuss the paper is my colleague, Olivia Tatarletti. Olivia coordinates our legislation and capacity building work. She is a qualified solicitor in England and Wales. Prior to joining LRI, she worked in the human rights field at Burnbeck and Pearce, and before that, in dispute resolution at Simmons and Simmons. Olivia, hello.
Hi, Pascal. Good afternoon.
Good afternoon. Good to see you. So for our audience tuning in today, can you perhaps start off by explaining a little bit about the paper and what the paper is about?
Yes, sure. And thank you for the introduction, by the way. So the paper we've published is presenting a comparative analysis of 5 Latin American climate change framework laws. They are from Mexico, Peru, Guatemala, Honduras, and Paraguay. And first, the analysis is sort of determining if and to what extent those laws meet the requirements of the Paris Agreement. And then the approaches of how those laws go about doing that are compared to each other to identify gaps and achievements, and also to draw out lessons and recommendations for other climate change framework laws.
Mm-hmm. And how did the idea for the paper came about?
So originally, the idea for the paper came about because we were looking at climate change framework laws in the region of Latin America, as COP25 at the time was scheduled to take place in Chile. This was then changed to Spain, in Madrid, where the conference went ahead. But the reason, kind of the broader context for it behind that, was that LRI had increasingly been receiving advice requests for domestic implementation of the Paris Agreement. And so this was leading us to look at what was already in existence in other countries. And many countries are developing new laws and regulations or reviewing existing ones as part of their response to climate change. So the idea behind the paper was that to support developing countries in this process, we could share with them lessons and recommendations from this analysis.
Mm-hmm. And why the particular focus on these 5 Latin American countries? How did you select them?
Yeah, that's a good question. So we first looked at actually which countries in Latin America have a climate change framework law. And that led us to look at the framework laws of those countries. And the reason for this is that we felt sort of framework laws provide a legal backbone of some sort for how a country deals with the global climate problem at the national level. So, for instance, we didn't consider the laws of other Latin American countries that still address climate change, but not as a distinct and comprehensive piece like a framework law does. And we're also aware that there's a draft laws in progress, a draft framework laws, for instance, in Chile, but we had focused on the laws that have already been passed.
Mhm. And why focusing particularly on framework laws? I mean, why that particular focus? Surely laws and regulations and policies are very important too, aren't they?
Yes, absolutely. I mean, the wider law and policy framework is paramount for the effectiveness of implementation, of climate change action, things like national or local governance, as well as the general societal characteristics are as well. But our analysis kind of was a bit limited due to time, resource constraints. And so these aspects, unfortunately, go beyond the scope of our research. So instead, we really only focused on framework laws.
Okay. And can you then, perhaps for the benefit of anyone listening today, explain what methodology you use, what approach did you take in this analysis?
Yes, so initially we developed a list of the provisions of the Paris Agreement that we felt have potential implications for domestic law. And this list is contained in the analysis table that is at the end of the paper. So if readers, the audience want to look at it, it is in the paper. And so based on this list, the authors reviewed the 5 climate change framework laws, myself being one of them, and we scored the different provisions of those laws against this list, assessing if and how the provisions were implementing the Paris Agreement. And subsequently to that, I looked at those 5 different analyses and their scores and compared the approaches in the laws to one another. So that's what the comparative analysis presents, is the results of those comparisons, and identifying gaps and achievements that are based on those results.
Mm-hmm. And of course, we want to know, how did these framework laws scored?
Yes, well, overall, the comparative analysis, what it does, it indicates that there is a moderate degree of readiness to implement at least the mitigation components of the Paris Agreement. So the other topical areas of the agreement, for instance, adaptation, means of implementation, the main ones, the laws don't appear to be able to implement those provisions as well. But really, I want to stress that these conclusions are not meant at all as a criticism of those countries' efforts to address climate change. Rather, the idea is to contribute to improving existing framework laws and to develop new ones in the future through the lessons and recommendations of the comparative analysis.
Mm-hmm. And can you suggest, or can you say what kind of recommendation did you have for the countries, and what conclusions did you reach?
Yes, absolutely. So the one of the conclusions is that in order to facilitate the national implementation of the agreement, really the framework law should seek to capture all the themes of the treaty. So that's, for instance, mitigation, adaptation, loss and damage, means of implementation, and so on. And related to this is the need for the national law and policymakers to understand the international rules, so the Paris Agreement and its rule book. And this could be done, for instance, punctually through capacity building, but also on a continuous basis by engaging them with the UNFCCC process and ensuring that there is a flow of information between the delegation who represents that country at the negotiations and the national law and policymakers. And another conclusion I would like to mention is that once the framework law exists, its effective implementation is key, because you can have a great law on paper. So this can only take place where there has been an engagement with industry and civil society groups. And from a legal standpoint, at least, what is key for the effective implementation is that the framework law itself provides for accountability and additional resources to ensure its operationalization.
Mm-hmm. Yeah. And a question which you might not have an answer to, but did anything surprise you in your research or in the findings that you had?
Huh. That is a good question. I guess there is one thing that is a little surprising, um, not completely unexpected, but a little surprising. And as part of the research, sort of what was apparent is that there was very little recognition of the concept of loss and damage in the 5 laws we reviewed. So for those who are, not familiar, in this context, sort of loss and damage refers to the irreversible harm that is caused by climate change, where adaptation is no longer possible. So it could be a catastrophe like a typhoon, or a slower process like a desertification or sea level rise. And so I guess what surprised me was that none of the laws reviewed specified how those countries will deal with those risks. But at the same time, the consequences of loss and damage for those countries are potentially serious. So, of course, there might be other laws or policies within the country that recognize and tackle the risk, but just not to have it mentioned, recognized more prominently, and addressed as part of a climate change framework law was a bit surprising. Yeah.
Yeah, no, I can imagine. And so now we have the paper. And do you have any plans on what to do with it?
We had grand plans for the paper. We wanted to present it on the margins of the COP26 conference, which was scheduled this year in Glasgow in the UK. But that has not been possible as the conference has been postponed for a year due to the global pandemic. So what we're doing is we are sending it to our contacts and we are publishing it online alongside this video, so that it might be useful for domestic law and policymakers nonetheless. And really, we are very much open to feedback, to hearing from people who have read it. And if there is interest in expanding the analysis, for example, by looking at other regions or laws, or to include policies and regulations, for instance, we are open to exploring those ideas as well. Thank you.
Thank you, Olivia, and thank you for telling us a little bit about the paper. If you're interested in reading the full copy, you can download an electronic copy from our website. If you go to further resources and then a briefing paper section, it will be there. And if you want to read it in Spanish, there's a Spanish version of the paper also available. Many thanks again for joining us today, and see you soon again, I hope.